Good morning and welcome to the first of the Fletcher Day 10-minute takeaways. And today I am lucky enough to be joined by Paul Nathan, who is a senior litigation partner and commercial draftsman at Fletcher Day. He was also a licensed insolvency practitioner acting as liquidator, receiver, and administrator of companies. And using the years of experience that he's gained in this, he will be setting up a new series of seminars for us starting in November about how to set up and run your company properly, using all of his skills and knowledge to advise company owners, large and small, on the common pitfalls. So good morning and welcome, Paul.
Good morning, Julie.
Lovely to see you.
And you too.
Okay, tell us a little bit about what you aim to cover in this seminar series.
Well, let me start by explaining that I wear various hats. As a litigator over the years, I've done a fair amount of company disputes, and they're very expensive, often where directors and shareholders, particularly shareholders, have fallen out with each other. And the companies are deadlocked. And also I've seen all sorts of problems with companies. Wearing my hat, I used to be a licensed insolvency practitioner for 20 years. I would be appointed as a liquidator, for example, of companies and see all the problems. And in some cases, I would sue the directors for things like wrongful trading. So from a litigation point of view, I see everything that goes wrong. I know why it's gone wrong, usually because of a lack of preparation, not forming the company properly, not thinking about things, not having any documents regulating it, and how it will be managed. And it's expensive. And then from those years of experience, I began to draft documents to assist people in forming and running companies properly, and therefore minimizing any fallout if things went wrong. And that's my commercial draftsman point of view. So the object here is to try and explain to people who are about to form companies or have already formed them, but have no regime in place, how they can better manage those companies and ensure that everything is in place to try and be successful. Quite often companies become successful, and that's when shareholders fall out, or shareholder directors, because one may be putting in more time in terms of generating fees, whereas the other may be the introducer work. So basically, I want to cover 10 points in respect of formation of companies. Quite often when people are forming companies, they actually don't realize that they have a significant number of obligations, both under law and equitable obligations. So what I'd like to do is briefly run through the 10 major things that I will cover in the course of the seminars. And the object of this is really to assist people in setting up companies correctly, running them efficiently, and therefore avoiding a fallout, which is really, really expensive. It's much less expensive to come to me in the beginning and for me to advise and to draft all relevant documents to help in the running of the company than it is if you fall out and then spend literally tens of thousands of pounds. I mean, it's easy to spend £100,000 in a contested shareholders dispute. I mean, that's probably a small figure. So let me start. The seminars are going to cover the following. Firstly, directors' obligations to the company, other directors and the shareholders. So directors in companies formed since 2006 are in a very powerful position. Basically, they have full unfettered power to do most things in running the company, making decisions, unless there are fetters on those powers, either in a director's service contract, or there may be fetters in the articles, which are adopted when the company is first formed. There are statutory duties owed by directors to the company, under the Companies Act 2006, which I'm not going to set out here, but obviously they'll be part of the seminar.
Yep.
Let's assume the company's set up, model articles are adopted with no changes, no shareholders agreement, and the company is merrily going on and trading. Everything's fine, no one's fallen out, but many people don't realise the records, the statutory records that they need to keep and file. So there are certain records that need to be kept, and I will be explaining what they are.
Yep.
Things have to be filed within a particular time. Failure to actually file them within that time can lead to company fines and actually fines against directors personally. Very important, yearly accounts have to be prepared, and depending on the size of the company, there are exemptions. There are small company exemptions where very minimal accounts have to be filed. Obviously, public companies, they file very extensive accounts. Another thing, very important, holding of meetings, and in certain circumstances, directors won't have a power to do certain things, and resolutions are required. So calling a general meeting once a year, you can call an extraordinary general meeting if you have to pass a resolution to deal with a particular thing that you want to do. They can be called. There's all sorts of provisions as to the notice periods, and these days you don't have to all be in one room. Written resolutions, the articles may provide that written resolutions can be done, so basically everyone signs off on the written resolution.
Yeah.
But important, and it's also an opportunity for, I mean, this will be more important for bigger companies, for, you know, maybe if there's sort of 10 shareholders, that sort of thing. Filing of documents at Companies House, very important. Mustn't forget to file, because as I alluded to a moment ago, failure to file documents can lead to fines, but it all can, in some circumstances, failure to file accounts in time can lead to the company being struck off.
Right.
And then you've got to make an application to restore it. And you have to explain away why you failed to either prepare and or file accounts. I will also be discussing preparation and filing of yearly accounts and what needs to be included. There's a, I think misconception may not be quite the right word, but I will use it. There's a general misconception that directors are completely immune from liability for the failure of a company. That's not correct. There are circumstances in which directors may be liable for companies' losses, which I will discuss. And if a company goes into liquidation and the liquidator considers that a director has been guilty, this is not criminal guilt, of wrongful trading, fraudulent preference, or general bad mismanagement of the company, the liquidator is actually able to bring proceedings directly against the director. There's no situation in which a member of the public or a creditor can directly bring a claim against a director. So a director has limited liability in that sense, but a liquidator has the power under the Insolvency Act to bring proceedings against directors if they have behaved in an incorrect manner, basically if they're guilty of misfeasance. So I'll be discussing that. And then I'm going to explain documents that every company should have. Now, when you form the company, the first thing you have to do is adopt the articles. Most people adopt under the 2006 Act, the up-to-date version of Table A. Well, it used to be called Table A articles, the model articles. And usually they don't need very much tweaking, but it's worth considering whether there are things in there that you want to alter. The model articles can always be altered to suit the company. So you start the life of the company with the memorandum, which used to be a long document, now is very short. It's basically 1 or 2 lines, and then the articles. And the incorporation documents will include who's the shareholder, who form the company, who the shareholders are. What you don't have is a shareholders agreement, which, in my opinion, is one of the most important documents you can have, even in a two-shareholder company. And shareholder agreements, director service contracts. You may want to fetter the powers of directors, and the easiest way to do that is to include fetters in a director service contract. It's basically an employment contract for a director. The other thing that's important is the assumption that you can just take money as directors, take whatever money you want. That's an incorrect assumption, because at the moment wrongful trading is suspended because of coronavirus and all of this sort of thing. But when wrongful trading is no longer suspended, directors may put their hands in the company till and take 50,000 while not paying their creditors. And so the best way to ensure that there is no problem with that is actually to agree that the directors will be paid a salary, and you can do that in the director service contract, although the salary has to be commensurate with the work and the results. The other thing is that once you're up and running, quite often companies get into trouble because they're providing services, they don't have terms of business, they end up having to sue their customers, clients, and that costs them money. And if they don't recover that money, then they're suffering a financial loss. So I think having good, solid terms of business in place, and particularly if you're supplying goods rather than services and you want to have retention of title and be able to take those goods back, very important. So those are the sort of things that I will be covering in the series of seminars, and hoping that people then have a better understanding of how important it is to form the company properly in the first place, and how to effectively have machinery in place to run it well.
Okay, it sounds very much as though often problems that occur in the future or further down the line are set up at the beginning, because things haven't been done necessarily correctly. Would that be?
Absolutely. Well, internal problems, absolutely. I mean, we can never legislate for customers or clients who don't want to pay your bill. Unless you've got a mechanism for taking money on account. I mean, as lawyers, when I work, I take money on account of costs. You can't always do that in every area, and particularly if you're supplying goods, then you are really not going to get paid until you've supplied them. And you may have some customer turning around and saying, oh, well, they were faulty. It may be the case, it may not be the case, but I pretty much heard every story there is to tell in terms of, but I think more fundamentally is a lot of times companies fail, and the fallout is extremely expensive because, for example, two people will go into business together and form a company. They've known each other for years. They may be friends, they may be related, parents and children, all sorts of things, and they work on the basis of trust. The worst thing, my greatest advice to anybody is don't enter into business based on trust. Trust is a funny thing. You may love somebody, they may be the greatest person you've ever known. You go into business together and one feels they're putting in more than the other, and then there's an argument. And typically what happens in many cases is people form companies with a 50% shareholding each. That's a disaster from the outset, because it's complete deadlock. Most things that a company needs to do can be done by an ordinary resolution. An ordinary resolution requires the votes of 51% of the shareholders. Some things require a special resolution that requires 75% of the votes of shareholders. But obviously, if you've got 50-50 and two people have fallen out, you have absolute deadlock. And there's very few places to go. You can, if you can't reach an agreement, quite often the situation is that you will have to wind up the company, petition to wind up the company on what's called the just and equitable basis. Or alternatively, one shareholder may not be a director and feels that the director is running the company in a way that is disadvantageous, and then can bring a petition for unfair prejudice. And so these are very expensive things. So the fundamental mistake is never, ever, ever have a company which is 50-50.
Okay, you'd say there's a top mistake that businesses make or business owners make is 50-50.
Completely, and I understand why, because you think when you're going into business that equality is a good thing, and you don't want to offend the other guy by saying, well, I want 51%. Sometimes it's easier, for example, where let's say two people are setting up a company and one is the main investor and puts in a lot more money. There's an argument that person should have the greater number of shares. But quite often, if both are putting in the same amount of money and both consider that they're equal, but the problem with that is that there has to be a mechanism by which one or the other is able to pass resolutions if they fall out. But what I try and do when I do a shareholders agreement is I agree the parameters of where they may fall out over something that should not be a company breaker, and that will be legislated for. And if something is a company breaker and there's no way back from it, then what I'm doing is controlling the fallout and what is to happen in those circumstances.
Okay, well, it sounds like it's going to be a really interesting series of seminars with some really useful information for business owners. We will be running this. The first one will be on the 23rd of November at 6 p.m. And if anyone would like a place, they can email seminars@fletcherday.co.uk and we will book you in and then send you the login details for that. In the interim, if you have any issues such as those described by Paul today, please feel free to contact him directly, paul.nathan, that's Nathan, so paul.nathan@fletcherday.co.uk, and he will be happy to give advice on the situation you find yourself in. Thank you for your time today, Paul, very much appreciated, and we look forward to the first seminar on the 23rd of November, and we will see you again very soon.
See you then. Bye.